The term estate planning usually conjures up a very specific image. We picture sprawling mansions, locked gates, and legal battles over massive family fortunes. But an estate is simply the legal term for everything you own. If you have a checking account, a car, a home, or people who rely on you for support, you have an estate. And if you don't write down exactly how you want those things managed, the government already has a backup plan for you. State laws automatically step in to decide who gets your assets and who raises your children. Ignoring the planning process effectively surrenders your life's work to generic statutes, letting the state dictate how your legacy is handled. This flowchart shows how the state's default plan works. It takes a central pool of assets and mechanically diverts them down rigid, generic pathways, completely ignoring your personal relationships and unwritten promises. Because there are no clear instructions, assets stack up at legal bottlenecks in probate court, creating severe delays, inviting public scrutiny, and setting the stage for bitter disputes among relatives. Creating an estate plan allows you to intentionally override this chaotic state default. You replace blind bureaucracy with your own explicit, legally binding instructions. The foundation of those instructions is a last will and testament. It outlines exactly who receives your property, and crucially, it is the primary legal document where you can name the guardians who will step in to raise your minor children. But a will has a distinct limitation. Even with clear instructions, a will must still be validated and executed through the public and often painfully slow probate court system. To avoid that court interference, planners rely on an advanced legal tool known as a trust. Assets transferred through a will hit a mandatory checkpoint at probate court, pausing the transfer. Conversely, a trust bypasses the court entirely, flowing directly to beneficiaries. This keeps your details off the public record, allowing conditions, like a time release schedule, to distribute funds gradually. So while a will is essential for establishing your basic intentions and naming guardians, a trust provides a streamlined, heavily controlled mechanism for executing your financial wishes. Up to this point, we've focused on what happens after death. But estate planning is equally critical for managing a severe medical emergency, where you are still alive, but medically incapacitated and unable to communicate. In that scenario, you need legally designated proxies. A financial power of attorney allows a trusted person to pay bills and manage your money, while a healthcare power of attorney authorizes a proxy to make medical decisions on your behalf. But a proxy still needs to know what you want. This is a stylized, advanced healthcare directive. It functions as your written instruction manual, outlining exactly what treatments, like life support, you want when you can't speak for yourself. By putting these medical preferences in writing, you remove an agonizing burden from your family. They never have to guess what you would have wanted during a high-stress crisis. There's also the immediate financial friction that occurs when someone passes away. Surviving dependents face a wave of unexpected costs, including outstanding debts, estate-related expenses, and everyday living costs, often before they can access inherited accounts. This bar chart demonstrates how life insurance acts as a financial safety net for those immediate costs. The death benefit injects fast, liquid cash into the estate, instantly offsetting the sudden spike in liabilities without forcing your family to scramble or sell off property. Pairing that liquid cash with careful tax planning ensures your wealth is actually preserved for your family, defending the estate's value against unnecessary depletion. A common mistake is treating an estate plan as a simple checklist item, a document you sign once, lock in a safe, and forget about. The reality is that your life is constantly shifting. Getting married, going through a divorce, buying a new property, or having a child are all events that immediately disrupt the structure of your estate. Whenever these major milestones occur, you have to proactively review and update your legal documents so they actually reflect your new circumstances. A truly effective estate plan evolves at the exact pace of your life, serving as an adaptable strategy that reflects your current world. Ultimately, estate planning is an active, present-day act of responsibility and care for the people closest to you. You are taking on a temporary logistical burden right now. In exchange, you permanently trade away chaos and uncertainty, leaving your family with lasting peace of mind.